that the affidavit of the government says that the Prime Minister has been cognizant of the issues relating to civil liberties, and that he believes at a time of 75th year of independence, nation wants to shed colonial baggage, including outdated colonial laws. And that's an observation, not an observation, but reading of the affidavit by the Chief Justice of India. And then he said we should not appear that we are unreasonable. Now there are concerns. One is cases which are pending, and the other is the issue of misuse, where the AG himself had said, Attorney General, the other day, that even chanting of Hanuman Chalisa is attracting sedition case, obviously referring to the Navneet Rana case in Mumbai. How are we going to protect these issues? The Solicitor General, Tushar Mehta, then interjected and said that the filing of FIRs and investigation are done by the state governments. Centre does not get into it. So I think a picture that is emerging of sedition law being misused, it's even Stevens between various state governments. It's the state governments that file those FIRs and cases, and they are ruled by all parties. So it's not a specific to one particular party misusing it. That's the discussion that has taken place in the court. Let's go to Rhythm Anand Bharadwaj, our Executive Editor, Legal Affairs and Governance, who's joining us on the phone. Rhythm, what do you make out of the proceedings on the sedition law taking place in the Supreme Court?
Let's tell you what's been happening today, Abhishek, in the court hearing with the Chief Justice of Solicitor General had said response from the centre's while the Chief Justice said, how long will you take for the reconsideration, to which Tushar Mehta has said, I'm not able to give an accurate reply. You see the tone and tenor and spirit of the affidavit, where he's talking about the Prime Minister who's taken a huge step forward to say they will re-examine the sedition law. The CJI then observes what we feel is the state has said they want to do something. It appears we should not be unreasonable. Let us see how much time we need to give. And then there's an affidavit that's been spoken of from the other side, where they say there is another disturbing aspect. When the privacy case argument was over, the centre said they are setting up a committee in marital too similar. CJI has noted the Prime Minister's intervention in the matter, which is extremely crucial here to remember. The Solicitor General says, I take instructions, discuss if the guidelines can be made. And Justice Kohli says, as Brother Justice Khan said, why don't you take instructions with the state to not proceed with the matter? Let me tell you, the biggest thing that's happened inside the courtroom as we are speaking is,
yeah, go ahead, Rhythm. All right, Rhythm, if you're there, I'm just bringing to your attention the observation made by Justice Hima Kohli, where she has said that, as Brother Justice Kant said, why don't you instruct the states to not proceed with the matter till the issue is under reconsideration? Essentially, the mind of the court is that the sedition law should be used lightly, and in any case, there should be some guidelines that till the time that review happens, no further arrests should be taking place under sedition law across the country, and that the centre should be issuing some kind of guidelines to the states. Is this right insofar as observation made by Justice Kohli is concerned, Rhythm? All right, we lost Rhythm there, but then this is an important comment coming in from Justice Hima Kohli, who's on the bench. It's a three-judge bench, remember, viewers. And apart from Justice Kant, it is Justice Kohli and, of course, the Chief Justice of India, Justice Ramanna. Justice Hima Kohli has said that why don't you instruct the states, and she's supported by Justice Kant, or she's seconding Justice Kant, that why don't you instruct the states to not proceed with the matter till the issue is under reconsideration? To which the Solicitor General added that I will take instructions and discuss if guidelines could be made, essentially meaning that the court is of the view that given the fact that even the Prime Minister wants a review of the sedition law, at least till the time that review happens, all cases where sedition law is applied, or Section 124A of the IPC is applied, to be more precise, no arrest should be taking place across the country. So essentially, in its soul, I think the court is of the view that the idea of sedition law should be tapered and toned down forthwith, pending a proper review, based on which it would be decided whether the law itself